this video, I would like to talk about the tribunals and especially the administrative tribunals. Very interesting, and it's a constitutional provision. Let us see how these tribunals are created and what are the different types of tribunals and the the various provisions and need, and how is it different from the regular courts. Okay, that is what my discussion is. So, tribunals and especially administrative tribunals. So, what is a tribunal? The first thing, tribunal is a quasi-judicial institution. It is a quasi-judicial institution that is set up to deal with problems such as resolving administrative or tax related or any other dispute. It is a specialized agency, quasi-judicial, semi-judicial, because it has other functions also. It performs a number of functions like adjudicating the dispute, any dispute, then determining the rights between the contesting parties, then also making an administrative decision, because administration is equally involved in it, then reviving an existing administrative decision, etc., etc. In fact, the word tribunal, it has come from the Roman law, and tribunal is from the word tribunes, which means magistrates of classical Roman Republic. Tribunes means magistrates of Roman Republic. Magistrates of classical Roman Republic. So, these are constituted. Why these tribunals? Tribunals are constituted with an objective of delivering speedy, inexpensive and decentralized adjudication of dispute in various ways. So, three things: it is speedy, inexpensive and even decentralized. Decentralized adjudication of disputes. They are created to avoid regular courts' route of dispensing the dispute. So, we can avoid the regular courts. The regular court route can be avoided in dispensation of the disputes. They are run parallel to the courts and generally are less formal, less expensive and less time consuming. It is less formal, then less expensive of course, and we can say less time consuming. Less time consuming. That is, these are some of the advantages, but they were not there originally in the Constitution. It is not that original provision of the Constitution or the 1950 Constitution which came into being did not have this provision for tribunals, and it was incorporated into the Constitution through the 42nd Amendment Act, and it was after the Swearing Committee recommendation. Okay, it was after the Swearing Committee recommendation, 42nd Amendment Act, and it introduced part 14A of the Constitution. 14A of the Constitution. The provisions for the tribunals are added there. Okay, and there are two articles. One is Article 323, Article 323A. and Article 323B. Two articles are added, and 323A was added, both are added through 42nd Amendment Act 1976, and 323A enables the the creation of central and the state administrative tribunals, CAT and SAT, and even a joint administrative tribunal is possible, that is between one or more states. There can be central administrative tribunal, then state administrative tribunal, and this can adjudicate. What can they do? It's an enabling. Article 323A is an enabling. It enables the center, the parliament, to set up central administrative tribunal, state administrative tribunal, or joint administrative tribunal. It's an enabling legislation. Using this, you can make a law. How exactly that tribunal will look like and all, it can be made by a separate law, but this is an enabling legislation, 323A, and it can adjudicate disputes related to administrative matters, disputes related to recruitment, promotion, then transfer, conditions of services, etc. And in public service. Okay, that is the idea under the union as well as the state governments. And the parliament can, using this article 323, okay, using article 323A, the parliament passed the Administrative Tribunal Act 1985. Administrative Tribunal Act 1985. Parliament passed the Administrative Tribunal Act 1985 to set up Central Administrative Tribunal as well as State Administrative Tribunal. Okay, so the Central CAT was created in 1985, and many states also provided with the State Administrative Tribunal. The difference here is the center only can make after a recommendation by the State Administrative Tribunal also. So this was created, and even the PSU employees can be, they can also be clubbed into this administrative tribunal depending upon, the provisions which are made. The chairman and the vice chairman of this administrative tribunal enjoy the status of a high court judge. The chairman and the vice chairman of this CAT and SAT enjoys the status of a high court judge, and the retirement age is 65 years for the chairman and the vice chairman, as well as the other members can be drawn from the administration. The retirement age is 62 years. Other members, the retirement age is fixed as the 62 years. But in this the administrative tribunal, certain employees are exempted. Exemption, which are those employees who are exempted? Exemption from administrative tribunals. Number one, the employees of the Supreme Court and the High Court. Supreme Court and the High Court employees. Number two, armed forces personnel. Armed forces personnel, and as well as the employees of the Secretariat of Lok Sabha and Rajya Sabha. Lok Sabha, Rajya Sabha, Secretariat. So they are exempted from these tribunals. So basically the tribunals will relieve the courts of overload, and it will speed up the process. That is the whole idea behind the case. And about this 42nd Amendment Act and about the tribunal, Supreme Court has given a very interesting judgment also, that is related to, the Supreme Court judgment was that these tribunals, when originally it was given, there was a provision whereby it was said that, once again, so Supreme Court in 1997, it has given a judgment, a 7-judge bench. One of the original provision was that any decision of the tribunal can be challenged only in Supreme Court. That was mentioned. But now Supreme Court has squashed that and declared that the tribunal judgment, the CAT or SAT tribunal judgment or tribunal award, can be challenged in the division bench, of the High Court, of the respective High Courts, where the High Court has jurisdiction. So please remember, High Court has jurisdiction over the tribunal award. In the respective state, wherever the tribunal is located, and that tribunal award can be challenged in the division bench of the High Court. So that verdict was given by the Supreme Court in 1997 itself. So tribunals are not above High Court. Originally, when the Tribunal Act was passed in 1985, it was said that the tribunal award can be challenged only in Supreme Court. But in 1997, a 7-judge bench has given this verdict saying that this can be challenged in the High Court, in the division bench of the High Court itself. So that is how Article 323A, and based on Article 323A, there can be central administrative tribunal and state administrative tribunals, as well as joint administrative tribunal, but the only thing is it can be created by the parliament. Okay, the center can create it, not by the states. So that is Article 323A, and 1985 Administrative Tribunal Act was passed, and that is how 323A came into, it was enforced. 323A was there in 42nd Amendment Act of 1976. But based on that 323A, it was an enabling legislation. Our Administrative Tribunal Act was passed in 1985. Okay, now coming to 323B. 323B, Article 323B. It says these are tribunals for other subjects. Tribunals for other subjects. So administrative tribunal is separately kept, that is under 323A for other subjects, like taxation, industry and labor. Taxation, industry and labor. Then like foreign exchange, import and export, land reforms, foreign exchange, import and export. Then food, sealing on urban property, election to parliament. There are many. There are Rent and Tenancy Act. So a series of for various provisions in income tax. There are various tribunals have been created. So Article 323B provides for tribunals for other subjects, such as taxation, industry, labor, etc., etc., etc. Now, how 323A and 323B differ? There are 3 aspects. How 323A differ from 323B? That is the question. First of all, 323A is only for public service matter. 323A for public service matter. Public service matter. Because it is about administrative tribunals. Administrative tribunal, CAT, SAT, and joint administrative tribunal for if one or two states request the center to create, then a joint administrative tribunal can also be created. But 323B is establishment of for certain other matters, okay, like taxation, certain other matters like taxation, sealing, rent sealing, this, that, okay, all other which we have mentioned, even foreign exchange, import, export. So all these aspects can come. So it is not about administrative service. That is number 1. Number 2, under 323A, these tribunals can be created only by the central government, by the center. Whereas 323B, the other matters, 323B can be created by the states also. By the states also. Okay. So, 323A, the administrative tribunals can be created only by the center, whereas the 323B, other tribunals can be created by the states also. And the third thing which we can say, not much different, we had only one tribunal for the center and one each for the state. Okay. So, one tribunal for center, that is the CAT, Central Administrative Tribunal, then one for each state, that is State Administrative Tribunal, one for, or one as a joint administrative tribunal. If there is no SAT in that particular state, then it will be 2-3 states put together, one administrative tribunal. There is only one for a state, the State Administrative Tribunal. And also, there is no question of a hierarchy. There is nothing called a hierarchy of tribunals here. CAT directly under the High Court, even the appeal will go to the High Court, even SAT directly go to the High Court. There is no SAT appeal is not going to CAT or anything. Okay, the State Administrative Tribunals verdict or other awards, appeal will directly go to the High Court. So, there is no hierarchy, directly under the High Court we can say. Whereas, under 323B, the hierarchy of tribunals are there. There can be more than one tribunal, various types of tribunals are there. Hierarchy of tribunals. There can be a series, below the one also there can be, all these provisions are there, and it can be a series of tribunals can be there under the Article 323B. So, these are 2-3 differences. And then as I told, the Administrative Tribunal Act 1985, Administrative Tribunal Act under 323A, it has created, it has given for the provision of Central Administrative Tribunal. Then the central government can, on a request from the states, a state tribunal can be created or a joint tribunal can be created, I already said. And whereas the other tribunals under 323B, there are so many tribunals, like we have Central Administrative, see the Income Tax Appellate Tribunal is there, Customs, Excise and Service Tax Appellate Tribunal, even GST Appellate Tribunal is there. So, a series of tribunals have been created. So, that is how various tribunals are created. Now, let me talk about the difference between a tribunal and a court. So, tribunals are either created under 323A or 323B. 323A means Administrative Tribunal, CAT, SAT, JAT, JAT. Then under 323B, a series of tribunals can be there for other matters. So, now the difference between a tribunal and a court. Difference between a tribunal and a court. So, administrative tribunals and ordinary courts both deal with disputes between the parties, of course, especially when it affects the rights. Okay. So, but there is some difference between the administrative tribunal and a court. Okay. So, first of all, a court of law is a part of the traditional judicial system. Okay. A court and a tribunal. Okay. A court is a part of the traditional dispute in a judicial system, and this court, judiciary, is a part of the organ of the government. Okay. We are three organs of the government, we always say, judiciary, executive and legislature, and it is, the state has four essential elements. You please remember, when we started with the state, a country has four essential elements: sovereignty, citizenship, government and territory. Please don't forget. Okay. So, this this judiciary comes under the government, and it derives its powers from the state. A court derives its powers from the state. Please remember, it is a very basic, the basic foundation of any state has government, and the government has judiciary. Government is divided into three parts. One is judiciary. But when it comes to administrative tribunal, it is an agency created by a law and with some judicial power. Okay. So, tribunal is an agency created by a law or a statute. Okay. It is created by a statute or a law with some judicial powers. With some judicial powers. Okay. They are created with some judicial powers. Number 2, we can say a civil court can try all sorts of cases, all suits of civil nature, all suits of civil nature. But administrative tribunals or tribunals can take up only specialized cases or other special matters which are conferred on them. Only special matters conferred on them. Only what is given to them, only that can be used. Number 3, the judges of the ordinary courts are independent of the executive, and judicial independence is a hallmark of any democratic setup. Judges are independent. Independent of judiciary. Sorry, judges are independent of executive. Judges are independent of executive. And the judicial independence is an essential element of any democratic setup. Judicial independence. Whereas the administrative tribunals or the tribunals, they are not independent. They are entirely, and in fact many a time even the appointment, everything, there is a lot of executive involvement. See, they are not entirely independent. They are not entirely independent of, and it is not independent of the government, independent of the government. There is a lot of cross connection between the government because they have additional, their administrative powers also. And then, the presiding officer of an ordinary court is 100% trained in law, or, presiding officer or a judge is fully trained in law. Fully trained in law. He is a lawyer. We have seen how a high court judge is appointed or a supreme court appointed. So, either in a high court judge, a law officer, judicial officer, at least of 7 years of experience, or 10 years of experience, or a lawyer in a high court for at least 10 years. So, presiding officer always are fully trained in law, whereas the presiding officer or the members of this tribunals may not be trained fully in law. He may be an expert in the field of the administrative matters also. He may be, the lawyers may be, the officers in a tribunal may be an expert in administrative matters, may be an expert in administrative matters. They may not be lawyers in the first, they may not have been lawyers, they may not have been trained fully in law, but still they can be appointed. Okay. So, the presiding officers or even the judges, now when I say presiding officer or the judges are fully trained in case of a court, but here they may be experts in their respective field. A judge of a court must be impartial, and independence and impartiality, neutrality is a must. A judge may be impartial, neutral when it comes to any matter. But in an administrative tribunal, the officers may be a party to the dispute, because the government is a party to the dispute. Because in administrative tribunal, they may be party to the dispute. The various tribunals which are created, and it is for the on behalf of the government is created. When there is a dispute from a common man, suppose the income tax appellate tribunal, income tax officer is sitting as part of the tribunal. Please see this difference. See, because suppose the income tax has given a notice for so many, say suppose 10 lakh rupee income tax notice to a person. Now this person is disputing this case. He has gone to the tribunal, and who all are sitting? See, some judicial officers will be there, but definitely there will be income tax officers also will be there. So the tribunal members, many of them are party to the dispute. They are not independent. Okay. So in a civil court, I mean, another difference we can say, in a normal civil court, the rules of evidence and procedure is very important. The rules of evidence and procedure is very important in a normal court. But in administrative tribunal, it is not exactly based on these rules of evidence and procedure. It is many a times based on the principles of natural justice, logic, the principles of natural justice. It need not be always based on the rules, evidence, procedure, etc. So, these are some of the differences. These are some of the differences, but most importantly, it has administrative function, and these tribunals are many a times created, and the government itself is a party to it. That is how these issues are there. And please remember, the idea is speedy justice, some solution to the problem. An officer said something, and now it is questioned in a tribunal, means rather than going to the court, going through the process of evidence and procedure and all, you are creating a setup where it's a quasi-judicial body, some judicial members, some administrative members, so that the matter can be resolved much faster and easier. So that is how these administrative tribunals are created. Now, in another video, I would like to talk about certain changes in the rules made recently, and the Supreme Court judgment and the subsequent controversy which is created as far as the appointment of the tribunal members. Okay, so this I will be taking up in a separate video. So this is about what are administrative tribunals and other tribunals. Article 323A and 323B created through 42nd Amendment Act. Then based on that, in the Tribunal Act was passed in 1985, whereby CAT, SAT, JAT all are created, and then other tribunals were created subsequently. So that is how the creation, how tribunals are different from ordinary courts. I have given a good idea, and I have also declassified or rather distinguished. I talk about the distinction between 323A and 323B. So now in the next video, I will be talking about some controversy related to the changes made in the appointment of the tribunal members and all by the government and the Supreme Court verdict. That is in the next video.